Today we'll be presenting the property management module of the CPD program. An overview of today's session will include pre-tenancy, tenancy, post-tenancy, rental management, and maintenance management. If we look at an overview of property management, it's really about leasing and lease management. And there we talk about the marketing of units, the application process, the screening of applicants, letting of the unit, and the lease management that happens post-signing of a lease. On the rental management component of property management, we will be looking at the rent deposits, setting rentals, increasing rentals, your billing system, as well as your rent collection system. And under asset management, we'll be looking primarily at maintenance management, facilities management, utilities management, and vacancy management. There's a basic formula for residential rental. There's a tenant who pays rent to occupy a unit. The definition of an agreement is between a landlord and a tenant that gives the tenant the right to use and occupy a rental property for a specified period of time. If we look at the pre-tenancy section of this module, we're going to be covering the marketing section, the application section, the screening section, as well as the letting section. If we look at marketing, why do we have to market our units? It's to attract the right customer. By the right customer, we're referring to customers that can afford, that meet the profile of the unit so that we don't have overcrowding and things like that. We also want to retain existing customers. And the main objective of marketing is really to avoid vacancies. Vacancies equal loss of rent, and therefore no landlord can afford vacancy. We also have to do market research. So we have to guide our landlord clients as to what rental they can charge in a particular area for a particular type of unit. In providing such advice, we are going to have to understand the demographic profile of that area, the socioeconomic profile of the area, and particularly the rental housing market. So what are other landlords offering in terms of their rental product? Your marketing efforts, what type of approaches and methods are you going to use? There's no sense in placing a large advert in your local newspaper if that is not the media that your potential clients would use. So it's important to understand what is the marketing approach and what methodology you're going to be using. It's also important to collect data on your clients on the basis of understanding what has worked in the past, what are the behavior trends, how do they service their rentals, what is the levels of non-adherence and use and maintenance of the properties. This essentially begins to give you a body of knowledge that makes you understand better what your marketing efforts should be. If we look at the application process, it's really about first providing information to a prospective applicant. You would have to give the applicant details of the property in terms of its size, its use, in terms of what rentals you would levy against that property, and what are the usage and the house rules of that property. You would also have to give them an understanding of what services you're going to offer. So that is dependent on the mandate that you have from the landlord. You may be responsible for leasing the property and managing the lease post that lease agreement. You may be responsible for the rental administration or not. And you may also be responsible for the asset management, which is maintenance management and facilities management. Once you've given that information, the applicant would then decide whether they would want to rent the unit or not. At that point in time, you've got to get an application form completed, and you've got to also then collect certain information for you to enable you to do the screening of that person. The information essentially that you would require at the application stage is personal information of the household and the applicant particularly, their residency history, their income and employment. So you want to check the stability of that person's income and their affordability. And you would also want to establish what the housing need is of that person. So the supporting documents would then include IDs of the household. It would include a payslip. It would include potentially a bank statement. You would also then ask the applicant to complete a form that gives you permission to do a credit check, and you may then proceed to the stage where you do an income and expenses with them. Once you've got all that information, you move on to the screening process. Now, what you need to establish in the screening process is whether that household meets the requirements of that unit. Is the household size suitable for the size of that unit? What you don't want is overcrowding and overusage of your unit, and with that comes higher maintenance and so on. So the second check is the affordability check, where you would check the net disposable income, if that is sufficient to meet the rental and other household expenses. You would do a credit worthiness check to see whether that person is not over indebted, is not a late payer. And the third check that is advisable for you to do is to check the bank account. So what you find in cases where people's salaries get paid into the bank, and immediately after it gets paid in, it gets withdrawn, and then you have stop orders that are not paid. If you find that type of behavior, that is a client that you wouldn't want to do business with. You would also look at previous tenancy records. So there's a portal called TPN, Tenant Profile Network, where you could check to see whether other landlords have perhaps not blacklisted the tenant for non-payment or for other non-adherence to their previous lease agreements. Once you've done that and the person is found to be affordable, the person is found to be suitable for that unit, you will proceed to the letting of the unit. That will really commence with an offer or the acceptance of that unit. The person would be required to pay the rent deposit, and the person would then be required to sign the lease agreement. Now, it is also preferable that if there's more than one household income to that household, that you get all the adults that are earning an income to sign the lease together, so that if one defaults, the other one can also be held liable for the rental. You also need to go through the key clauses of the lease so that they understand there's a deposit, they understand when rental is due, they do understand that how maintenance will be handled, who's responsible for what the other house rules are, whether pets are allowed, and so on. And then you need to do a pre-inspection of the unit once they move in. And that is a legal requirement of the Rental Housing Act, that you've got to append that pre-inspection to the actual lease agreement. You've also got to ask the applicant then to go and connect the electricity and water at the municipality. And then there's a process of the person moving into the unit. So that is a procedure on its own. There's the handing over of the keys to the unit. There's the pre-inspection that has to be done, and that's got to be signed off. And if it's found that there's any maintenance work that needs to be done by the landlord, then that will become the subject of that pre-inspection not being final until that works have been done, and the pre-inspection then signed off and appended to the lease agreement. The lease agreement. Key elements of the lease agreement should include the names and addresses of the parties for the purpose of formal communication, the description of the dwelling, the amount of rental, the escalation of the rental, the frequency of the payment and how to pay and where to pay the rental, the amount of the rental deposit. And some leases would make provision for the rental deposit to be increased when the rental increases, so that it keeps up with the rental as it increases. It's got to include the lease or notice period, information related to the rights and responsibilities of the tenant and the landlord, information related to obligations of the tenant and the landlord, and information on the amount of any charges payable in addition to the rental. So you may have a situation where it's a sectional title complex that you're renting out and there's levies that need to be included, or utilities are stripped out of the basic rental and that is in addition to the basic rental. So essentially these are the components of a lease agreement. The types of leases that you can get a month-to-month lease, which generally the tenant or the landlord has to give 1 month's notice to, or you could get a fixed period lease. If the tenant wishes to exit the lease prior to the fixed period, that tenant would be liable to honor that rental for the entire duration of the lease agreement. And that would be the same for the landlord if the landlord wishes to exit before the fixed period has expired. If a fixed period lease has expired, it is able to be extended on a month-to-month basis. It then becomes a month-to-month type of lease post that expiration of the fixed period. That concludes the pre-tenancy component of our module. We're now going to move on to the tenancy component of the module. We're going to cover aspects of communication, complaints management, non-adherence, and dispute resolution. On communication, why should we communicate with the tenant once the tenant has moved in? We want to build a relationship, and we want that relationship to be built on trust. We want to be able to talk to the tenants about rental payments, about increases. We want to be able to talk to the tenant around non-adherence, where they don't comply with certain clauses of the lease agreement. We want to be able to deal with complaints, and not necessarily only complaints from ourselves as the property manager, complaints from the tenant, but also complaints from neighbors. And then we want to be able to talk to the tenant around maintenance. But the most important reason is to build a relationship of trust. We shouldn't only be communicating with the tenant on the basis that we're dealing with either a complaint or non-payment of rental, or the fact that maintenance needs to be done and is not done. Because it is proven that if we build a relationship and we have regular house visits to the unit, we are able to better get tenants to behave in the way they should be in terms of what the lease prescribes. And it also gets them to pay regularly. So the way in which we communicate with tenants is that we can continuously remind them of the house rules. We can have telephonic conversations with them to just check in to see if everything's going fine. We can send out circular letters when things need to be communicated around rent increases or general complaints that are coming from that complex or that unit. And then we can do house inspections, or what we would call house visits, where you have a friendly visit to the unit and you're able to then see what the general state of repair is, whether those occupants that they said would be in the unit are still there, and whether the facilities around the outside of the unit are still being cleaned and maintained, gardens are kept neat, or so on. You wouldn't want to leave the tenant in the unit for years on end and find at the end of the lease that the unit is trashed, the facilities have not been maintained, and you have this major maintenance to deal with. Moving on to complaints management, and we're talking mainly about complaints coming from the side of the tenant or the tenant's neighbors. We're saying that the principles of complaints management is that it must be responsive. It must be responsive in that it must be dealt with promptly, and that complainants must be treated courteously. It must be efficient, so it must be proportionate and appropriate to the matter being complained about. Don't make a big thing about a small thing. It must be fair, so it must be impartial, confidential, transparent, but most importantly, it must be consistent. You can't say to one tenant, there's no pets allowed, and allow pets in the next unit. So your message must be consistent. If that's what the house rules say, that is what it says, and that's the only thing that you can communicate. The system in dealing with complaints, you should have a complaints form that tenants have readily available or neighbors have readily available so that they can formalize the complaint. You would then need to do an investigation to verify whether that complaint is valid or not. And that would entail you in having to engage with the parties involved. So it may be that you're dealing with a complaint from the tenant and you can deal with it as such, but it may be that neighbors are complaining about a tenant, in which case you would have to engage all parties separately, bring them together, and try and get to some type of a resolution. If the complaint is not addressed by the tenant, it can lead to cancellation of the lease and eviction. If the tenant is not happy with the landlord or the estate agent acting on behalf of the landlord, then the tenant has recourse to the rental tribunal. So those are the mechanisms of dealing with complaints that are unresolved. It then becomes external to the organization. But you would first deal with it internally, and if that can't be resolved, you would then seek external recourse. And non-adherence, very similar, including dispute resolution, very similar to the complaint system. The principle around non-adherence to any clause of the lease agreement is that it leads to cancellation of the lease and it leads to eviction. The system again is identifying, and in the case of non-adherence, you're not going to have a complaint that comes in. You are going to identify that the tenant is not adhering to a certain clause of the lease agreement. You would then have to gather evidence, because remember, for eviction, it's easy to get an eviction order for someone who doesn't pay rent, because there's a lease agreement that's clear, there's a billing system that shows you that the person hasn't paid, and the courts would use that. But in the case of behavioral issues or complaints or non-adherence, it's much more difficult to prove. So an example would be the person continuously makes noise and the noise carries on until 4 o'clock every morning, or the tenant is running a shebeen from the unit. One would have to gather enough evidence to prove that that is what is taking place in that unit before one can issue any notices to correct the situation or notices to cancel the lease and ultimately the eviction order. Moving on to dispute resolution. The principles of dispute resolution is that it must be accessible to tenants. The information around the process and the options that they would follow in the case of a dispute needs to be known. It needs to be fair to all parties. There must be a balance of power between all the parties. So you must create that environment where all opinions are valued and all facts are evaluated objectively on their merit. It's also got to be built on trust and mutual respect. So you've got to cultivate positive and respectful relationships, create a positive climate that is ideal for resolving disputes. If you don't resolve disputes, disputes will become conflict, and conflicts are much more difficult to manage. So one would ideally try and create the mechanisms to have the disputes resolved before it becomes entrenched and into a conflict situation. The further principles, there must be willingness on everyone to make it work together. And the solution must also be attainable. It can't be an unrealistic solution. There must be acceptance by all parties. So it requires an open mind. You need to work to a consensus or at least to a compromise. So it's a give and take situation. And there must be a good communication strategy about listening and speaking carefully and respectfully to all of the parties. The methods for dispute resolution, the complainant will lodge their complaint. You would gather information and evidence. You engage the affected parties, probably also separately and together. You would pronounce on your resolution, and if it's not resolved, it could lead to the termination of your lease as well. The methods that you would follow would be, you would negotiate first, you would try to mediate, you would try to do some type of conciliation. It could then move to arbitration or litigation, which is then out of your control. Once it moves to the arbitration process, there's the rental housing tribunal that can be used to deal with this dispute. And ultimately, if that's not resolved, you could resort to the courts. If we move on to post-tenancy, which is the cancellation of the lease, and it's the cancellation of the lease by either party. It could be cancellation on the landlord side, or it could be cancellation on the tenant side, and it includes the eviction of a tenant. So one of the key components of the cancellation of a lease or the termination of a lease, it's about giving or receiving notice in terms of what the lease prescribes. If it's a month-to-month lease, it's 1 month's notice. If it's a fixed period lease, it's for the duration of that fixed period lease. It is good practice for the estate agent on behalf of the landlord to accept that notice in writing. And in that letter of acceptance of notice of the notice period, it's important that the person then explains what is the requirement from the tenant during that period of notice. So what should be communicated is how will maintenance be dealt with? How many days will the tenant be given to fix up their maintenance responsibilities? How many days will the landlord be given to fix up their maintenance responsibilities? The fact that rental is payable in that last month, you can't deduct the rental of the last month from the rent deposit. The fact that the deposit needs to be refunded back to the tenant within 7 days if there's no maintenance issues, within 14 days if there's a maintenance issue, and within 21 days if the tenant has just absconded from the unit. So the Rental Housing Act is prescriptive about how the rental deposit will be dealt with. There should be an exit interview. It is important to do that to gather information around why the tenant is leaving, whether the tenant was dissatisfied with the product or your service offering, so that you can improve your property management service offering going forward. And there's the matter of when and what time and how will the keys be handed over on that last day of the month when you move out. The key components of moving out is that there's a final rental account which must be paid and cannot be deducted from the deposit. There's the handover of the keys, the date, the time, and the time at which the post-inspection is going to be done. Remember, the pre-inspection that was appended to the lease agreement becomes the post-inspection sheet, because that serves as a guide as to what condition that unit was in at the time when the person moved in. And that should be the condition that the unit should be when the person moves out, fair, wear and tear taken into account. There's a final rental account. So that rental account has to be appropriated in many ways. Firstly, the deposit must be appropriated, and the Rental Housing Act clearly prescribes that the rent deposit must accrue interest. So that interest must be appropriated into the rental account, and that if there's any maintenance that the landlord had to undertake on behalf of the tenant, those costs must be added to that final account. And then the deposit needs to be refunded, as we said, either within 7, 14 or 21 days as prescribed by the Rental Housing Act. If it's an eviction for non-payment of rent specifically, you could achieve that within 35 days. So on the 1st, you send out your rent account. On the 7th, you send out your letter of demand or a cancellation letter if you want to be as hard as that. On the 20th, you could get to a summons. On the 21st, you could issue a default judgment or summary judgment. You could also apply for emoluments and attachment order, because that allows you to attach that person's salary for any outstanding rental, and you can then get your eviction order, and after that you would then get the sheriff to undertake the eviction. And after the eviction, you could also then have a notice of sale for the property or the furniture that was in the unit at the time. So it is quite possible to do this in a matter of 35 days. If you're holding 1 month's deposit, then you're actually just losing 5 days worth of rental. But it's extremely difficult to do that in this period of time if you're going to outsource this aspect of your rent collection. Moving on to rent management, we're going to briefly be talking about the rent deposit, the rent setting, the increase, the billing, and the collection. The key aspects of rent administration is how to set your rent deposit. Is it equal to 1 month's rental? The fact that you may not get an eviction over 30 days means you may want a 2 months deposit, which gives you more time to get an eviction done in 60 days. It also is important that you understand what does it cover. And the issue of interest, remember, if it's just a landlord and a tenant, then the deposit must be placed in an interest-bearing account and the interest must accrue to the tenant. If it's an estate agent under the Estate Agency Affairs Board, the interest doesn't have to be paid, and interest can then be accrued to the trust account of the estate agent. Rent setting, it has to be market related. It's no use advising the landlord that you're going to be setting rental and that rental is not market related, it's above market, because then no one's going to rent that unit from you, because they would then go and find a unit that is market related. At the same time, the landlord wants to see profit from a return on his investment. So you've got to measure that against what the market related rental is. And you've got to also check the cost to income. You can't have a rental set and the cost of that unit is actually more than that rental income. It just doesn't make sense. You've got to think about rent increases. Is it inflationary based? Is it inflation plus? Because remember, your expenses and your cost for managing the property are going to inevitably also increase almost at the rate of inflation, if not more. So it's important that you understand what your inflationary based or what your increase rate is going to be, and at the same time how frequent it's going to be. You are able to increase rentals every 6 months if you have a 6-month fixed term rental, or generally it's annually. From a billing point of view, you've got to ensure that you have your deposit administration in place. So it's in a separate account. It accrues interest, and that interest should be accruing to that tenant. You've got to raise your rentals correctly. So your statement or your account needs to be correct. You've got to capture payments as and when the tenants make those payments. And you've got to send out monthly accounts or statements to that tenant. The next element is around rent collection. So if the person doesn't pay by the first, it is good practice that you give a courtesy call to that tenant, you send them an SMS, or you use other social media to try and inform that tenant that they're now in arrears. If they really don't respond to that, you should be looking at a letter of demand and a cancellation notice thereafter. And if rental is still not paid, you need to move to eviction. In all of this process, there could be where you are able to make an arrangement to pay off. But if you are going to entertain arrangements for arrear rental, you must remember that the tenant must show affordability for that. Moving on to asset management, we're going to look at maintenance, facilities, utilities, and vacancy management. From a maintenance management point of view, on behalf of the landlord, you really want to preserve that landlord's asset. And the asset must be fit for purpose. So the tenant must be able to enjoy the full use of that unit that they're renting. So the maintenance has always got to be fit for purpose. The general responsibilities, generally in terms of a lease agreement, the tenant is responsible for the inside of the unit, fair wear and tear excluded, which the landlord is responsible for. And the landlord is responsible for the outside structure, the electricity, and the plumbing. Best practice time frames for the various types of maintenance. And emergency maintenance needs to be dealt with within 3 to 12 hours. That would be a burst geyser, for instance. It needs to be responsive. From a responsive point of view, which is your day-to-day maintenance, you could do that within 3 to 14 days, provided that you inform the tenant that that is the time frame you're going to take to do the responsive maintenance. That's when a complaint comes in. And then unit turnover. Remember, when a tenant moves out and a new tenant has got to move in, you may need a few days to undertake some maintenance works to bring that unit back to its original state. It's important to try and shorten that time as much as you can, because remember, whilst it's vacant, you are not earning any rental on that unit. The procedure for maintenance would really be a complaint form, an inspection of the unit to confirm what the exact maintenance requirement is. You need to get your maintenance contractor to deal with the maintenance, and then once the maintenance has been undertaken, you need to do an inspection together with the tenant to confirm that the maintenance was addressed. If we look at facilities management, and it becomes more important when you're managing a complex of units, in that the gardens need to be kept. The outside areas like the stairwells and the drains outside and the general communal areas need to be clean. You may need security in these complexes. And any other facility that may be in a complex, you may have a pool, you may have a laundry, any other complex is then your responsibility as the property management agent to ensure that these things are taken care of. If it's an individual property, it's important that you do your house visits to see whether the tenant is actually keeping the gardens clean, keeping the outside areas clean and well maintained. If we look at utilities management, we know that we're in an age where the municipality doesn't really fulfill its role in terms of reading meters correctly, and also in just general billing. There are many queries that happen in the municipal account that's received. So this becomes an additional responsibility on the side of the estate agent and the landlord to ensure that the billing is correct, to query it if it's not correct, to reconcile it, and to make sure that it is passed on to the tenant. There's also another requirement that begins to say that if the tenant doesn't pay their bill, that they would, the landlord becomes responsible for that bill. Moving on to vacancy management. Generally it's covered by the leasing of a unit, which we have covered, and it's covered by the maintenance processes. What we want to emphasize is that vacancy equals loss of rental. We need to shorten the turnover time for maintenance to enable the unit to be rented out as quickly as possible. We need to make sure that the tenant leaves on the last day of the month and hands the keys over so that we can take possession of the unit and get it rented out as soon as we can. And we need to make sure that the new tenant has been screened, they've paid their deposit, they've signed a lease agreement, they've connected their municipal account, and this should be done by the 25th of the month preceding the date they're going to be moving in. And then we need to make sure that we have the process in place for the handover of the unit. Thank you. This brings me to the conclusion of the presentation. Please remember to answer the 10 multiple choice questions to obtain your 5 verifiable CPD points for this session. Thanks.